This is Stan J. Catterbone and Advanced Media Group. It's now 12:35 p.m. on Friday, February 11th, 2022. I'm going to do a public statement today, and I'm at 1250 Fremont Street, Lancaster, PA 17603 in my home office, in my basement home office. This is a two-story home, so there's two stories above me, for those that don't know. 1252 Fremont Street is right next door, connected to that wall back there. They're the people that have been filing the fabricated charges against me in Lancaster County Court of Common Pleas since 2017. I'm going to read something on that in a minute. First, though, I'm going to read the public statement. You have no idea of the torture when your brain is hijacked by artificial intelligence through the use of microwave weapons. It is the ultimate in pain and suffering. Welcome to the world of HAVANA syndrome. I've been a federal whistleblower since 1987 regarding International Signal Control, or ISC, an international arms dealer and a black budget company of the CIA and the NSA. Indicted in 1991 as one of the largest frauds in the United States. James Guerin and Company deserve a presidential pardon. In 1987, ISC merged with one of the largest defense contractors of Great Britain, Ferranti International, in a billion-dollar merger. All of my charges back in September 2nd, 1987, were dismissed in March of 1988 by then Lancaster County District Attorney Joe Madenspacher. Now, there were about 8 or 9 charges, 4 or 5 were felonies. Then, in 1991, ISC was indicted in November, and again, I was victim to a vast criminal conspiracy to cover up my whistleblowing activities in 1987. Now I am being covered up due to my victimization of microwave weapon attacks and the vast COINTELPRO operation spearheaded by the Lancaster City Police. Now I'm going to read something. In December 2016, I filed a protection from abuse order against my brother Stephen. And I'm going to read what I wrote it. Now, what I did was I filed it in the Lancaster County Court of Common Pleas Prothonotari's office. I should have filed it in the Register of Wills, I think it was. Anyway, I'm going to read the PFA. Defendant did on occasions threaten the plaintiff by making fists at the plaintiff while eating breakfast. During same said period, defendant did make alliances with the occupants of 1252 Fremont Street while said occupants were making threats, harassing, and stalking the plaintiff. On August 26, 2015, defendant did move with 3 dogs to Carlisle, Pennsylvania to live with our brother, Dr. Philip Catterbone, until December of 2015, when defendant, Steve Catterbone, moved home to Coral Gables, Florida. From 2010 until the present, and while living at 1250 Fremont Street, the defendant has never made any financial contributions to any household expenses or capital improvements, including but not limited to property taxes, insurance, electricity, or utilities, yet still maintaining a 25% ownership and while having some $100,000 in cash assets. Now, I filed that on December 12th of 2016. Now, back then, the Ramirez family of 1252 Fremont Street just moved in next door in May of 2015. Now, in February, they visited the house, but it wasn't finished yet. They moved in May. There were weeks, at least weeks, where they were cooking food and sending it next door to us. Brunilda Ramirez. I mean, trust me, they are nothing like they are today. And who some of those people are in that house, I don't know. Anyway, I filed that back on December 12th of 2016. So this stuff with these charges is phony, fabricated, all set up. Most likely by Clark Behringer, the lieutenant former lieutenant of Lancaster City Police, who filed 3 PFAs or 3 mental health warrants against me. So that's a little rundown. Now, the first Ramirez stalking charge, I'm going to tell you what happened. They were stalking me. Ashley in the van was sitting in my parking space, and the Jeep was sitting across the street with, I guess, Denise's boyfriend. He was in and out of here yesterday, moving cars around like mad. Anyway, they were stalking me. So I went up to Manor Shopping Center, did some errors, came down Charles Road, and turned my video cam on to record myself to see if they were still there. So I pulled down Fremont, and there they were, still sitting there. So in my video cam, I said, well, I'm going to follow Ashley. Well, she took off. She left from sitting in front of my house in her car. They were both in their cars. Proceeded down Fremont Street. I turned right on Euclid Avenue. I never followed her. I said I was going to, but I never did. I turned right on Euclid and went around the block and parked because they left. And they filed stalking charges on me. That's how it all started. And for that, I get 15 years probation. 15 years, 16 years. Now, I get a newsletter called the Harvard Law Review. And I get newsletters, I guess, once or twice a week from them. Now, yesterday, I got a newsletter and had a case. It has different cases, different types of cases. It had a case titled The Right to Be Free from Arbitrary Probation Detention. This fits me to a T. So I'm going to read part of what it said. Now, it's about a U.S. Supreme Court case. So I'm going to read it. In 2010, the New York Police Department arrested 16-year-old Khalif Browder on suspicion of stealing a backpack. New York City jailed Broward for 3 years without trial on Rikers Island, where he endured abuses by guards and other inmates and spent nearly 2 years in solitary confinement, though Browder's case was ultimately dismissed, the criminal charges. His confinement was punishing. In 2015, Browder hung himself. Since Browder's tragic death, waves of activism pushed New York to restrict long-term solitary confinement, ban solitary entirely for anyone under the age of 22, and eliminate money bail for most misdemeanors and non-violent felonies. But the bail reform would not have helped Browder, and little attention has been paid to why. For most of the 3 years, Browder was not held on bail. He was stuck on Rikers Island because he was suspected of violating his probation. Now, 2019, that's exactly what they did to me. Judge Reinecker had a hearing, probation hearing, in March of 2019, and he refused to release me or set bail until trial. So I had to sit until October and pled out with a no contest, which means I did not admit any guilt. So we did a plea deal, and the charge was reduced from a felony to a misdemeanor. I'm going to read on. When someone is charged with a crime, the government can detain them prior to conviction on proof that release would either 1, interfere with the administration of justice, or 2, pose a danger to the community. Indeed, the Supreme Court has explained that the fundamental nature of a person's strong interest in liberty requires that a governmental deprivation of that liberty have a legitimate and compelling justification that is narrowly focused on the purpose of the deprivation. Likewise, when the state seeks to civilly commit someone to a mental institution, it can overcome the constitutional right to freedom pursuant only to a carefully limited and sharply focused legislative scheme requiring clear and convincing proof of dangerousness due to mental illness. Of course, they're always trying to do that to me, too. For the government to deprive someone of physical liberty, it must follow fair procedures, and it must also have a legitimate and compelling reason that is narrowly focused on the purpose of the confinement. but no substantive justification is constitutionally required to jail any of the nearly 4 million adults on probation in this country if they are charged with a probation violation. Once a probationer is suspected of committing a new crime offense, a suspension violation, or non-criminal violation of probation conditions, a technical violation, their probation officer can trigger a revocation proceeding. That's what Lindsay, after my probation, is trying to do now with this non-custodial hearing. She didn't get one, but she's trying. Though the process differs by jurisdiction, the Supreme Court has mandated two hearings, a preliminary detention hearing and a final revocation hearing. In the preliminary hearing, probationers are routinely detained until the final hearing based solely on allegations of a violation. Criminal proceedings just to be detained in the separate probation revocation proceeding. Preliminary probation detention can last for weeks or months, and in cases like Browder's, where the probation detainer is tied to an underlying criminal charge, the incarceration can last years, even though the government never had to substantially justify the detention in the first place. Hear that, Lancaster County Court of Common Pleas judges? Though probation is often seen as a way to combat mass incarceration, in some jurisdictions, most people in jail are there because they are suspected of violating probation. In Philadelphia, for example, listen to this, over 56% of the jail population was held on a probation detainer as of September 2018. And because probation is now the most common criminal sentence in the United States, the specter of probation detention hangs over the nearly 4 million adults living under probation supervision. In the United States, liberty is the norm unless you are on probation. This note argues that there is substantive due process right to be free from arbitrary probation detention. The right derives from the 14th Amendment's protection of liberty and the corresponding requirement that deprivations of fundamental rights satisfy strict scrutiny. Now, I've been arguing the same thing in the Third Circuit Court of Appeals, which is where my habeas corpus is. Physical liberty is undoubtedly a fundamental right, no less so when someone is serving a sentence of probation. Though the Supreme Court has explained that the liberty of a probationer is conditioning on adding by the terms of probation, it has never said that a probationer's liberty interest is not fundamental. Indeed, many of the court's cases have explicitly recognized that a fundamental liberty interest inheres in a sentence of probation. Now, I sent this out, the entire case out to everyone yesterday. So they better read it. Anyway, that's the statement I wanted to make today on Friday, February 11th, 2022. Another thing, today is Sheryl Crow's and Jennifer Aniston's birthday. Their birthdays on the same day. I believe Sheryl Crow is turning 60 and Jennifer Aniston 53. It's now 12:49 p.m. Friday, February 11th, 2022. I'm at my home office. This is Stan J. CATERBONE Advanced Media Group at 1250 Fremont Street, Lancaster, Pennsylvania, 17603. Signing off.